Assault in the third degree NYPL Section 120. Assault in the third degree, as defined under New York law, is a serious criminal offense with potentially life-altering consequences. This charge can result from intentionally or recklessly causing physical injury to another person or acting with criminal negligence. How to beat a third-degree assault charge? One of the most compelling defenses in such cases is proving you acted in self-defense. Under New York law, you are allowed to use reasonable force to protect yourself or another person from what you perceive as an imminent threat of physical harm. This means that your perception of the threat and your response should align with what any reasonable person would believe and do under the same circumstances. Here are some steps to strengthen your self-defense claim. 1. Evidence. Gather any physical evidence and eyewitness accounts that support your version of events. Photos, videos, and credible witness testimonies can be crucial. 2. Consistency. Make sure your account of the incident remains consistent over time. 3. Proportionality. Show that your use of force was proportional to the threat. The force used should not exceed what would be considered necessary to prevent the danger. 4. Legal assistance. A knowledgeable attorney can effectively present your defense and handle the complexities of the legal system. By proving that you acted out of a reasonable belief that you were in imminent danger, you can establish a strong self-defense case, potentially leading to a dismissal of the charge against you. Defenses. When facing charges of assault in the third degree, several legal defenses may be applicable, including physical injury. The key element in this offense is that the injury must meet a certain threshold of injury to warrant a charge under NYPL Section 120. While it isn't necessary to prove that the injury was severe to prove charges of third-degree assault, the injury must be more substantial than a complaint and must be substantiated by evidence. If the defendant can demonstrate that the injury does not meet this threshold, it may serve as a defense. Self-defense. To successfully assert self-defense as a defense, the defendant must typically show 1. They reasonably believed that they or someone else was in immediate danger of physical harm or death. 2. Their use of force was necessary to protect themselves or others from that danger. 3. The force used was proportionate to the perceived threat. Penalties. Assault in the third degree is classified as a Class A misdemeanor in New York. The potential penalties for this offense can include a jail sentence of up to 1 year. In addition, instead of jail time, the court may impose probation of up to 3 years, during which the defendant must comply with certain conditions. The court may also impose fines as part of the sentence, and the defendant may also be required to compensate the victim for medical expenses and other losses. Assault in the third degree, NYPL Section 120. A person is guilty of assault in the third degree when 1. With intent to cause physical injury to another person, he causes such injury to such person or to a third person, or he recklessly causes physical injury to another person, or 3. With criminal negligence, he causes physical injury to another person by means of a deadly weapon or a dangerous instrument. What is the sentence for assault in the third degree in NYC? 1. Not more than 364 days in jail and/or 2. Up to $1,000 in fines. The penalties listed above are the maximums that can be doled out for a conviction. However, depending on the situation, it may be possible to reduce or avoid penalties by casting doubt on the prosecutor's case or demonstrating that mitigating factors were present. Orders of protection related to a New York City assault. When a person has been charged with assault, the district attorney will request an order of protection. The order of protection makes it mandatory that a person is away from the complaining witness. An order of protection for assault in the third degree will continue in effect up to 5 years after conviction. A person convicted of harassment, second degree, or disorderly conduct will be subject to the order of protection for 2 years. An ACD is an adjournment of contemplation of dismissal. This means that the order of protection will continue to be in force for 6 months starting from the date of the ACD's acceptance. If the assault charge is connected to domestic violence, the order of protection will apply for 12 months starting from the date of acceptance. Dropped charges versus dismissed case in NY. The district attorney cannot dismiss a case against a defendant unless a charge has been filed. However, a charge can be dropped either before or after a case has been filed. In other words, a charge can be dropped before trial in New York City. Alternatively, it's possible to file no charges. In this case, the DA decides not to file a lawsuit after an arrest. This scenario is usually the most ideal outcome for people who have been arrested in New York City. An experienced New York criminal defense attorney can help you to increase the chances of your case being dismissed, dropped, or not filed. Attorney for criminal defense Russ Kaufman is experienced in fighting for the rights of those who are charged with an assault or attempted assault. Experienced NY criminal defense attorney Lebedin Kofman LLP. Whether you did not intend to cause physical injury, or you accidentally struck someone, do not hesitate to let our firm fight for you from start to finish. We provide each of our clients with attentive and personalized legal representation to ensure we get the best possible outcome in your case. Contact us today at 646-663-4430 to discuss your case with our New York attempted assault lawyers. Our skilled NY attorneys may be able to help you protect your rights and your freedom if you are facing New York assault charges. Serving clients in the Bronx, Brooklyn, Manhattan, Staten Island, and Nassau County.